Good afternoon, everyone, and welcome back to this week's episode of the Digital Law News produced by Anson Evaluate. I'm Amelia Davies, an apprentice solicitor at Digital Law UK. I'm joined by my colleague Peter Wright, and we're just going to run through some news stories which have been coming up this week. I'll pass over to introduce himself, and then we will get started.
Thanks, Amelia. My name's Peter. I'm a solicitor and a managing director of Digital Law, and we wanted to share with you this week some of the key stories with regards to law and technology that have been in both the national and specialist press. So I'll hand over to Amelia to take us through the first story.
Thanks, Peter. So our first story today is looking at WhatsApp, and I mean, surprise, surprise, WhatsApp is coming up in our podcast yet again. And so this particular story is looking at WhatsApp not lowering security of its messenger service. So if asked by the government to weaken the encryption, so WhatsApp is using end-to-end encryption, and it's saying that it will not accept weakening the security. This is under the government plans in order to detect child sex abuse images, including the possibility of scanning private messages and devices for any such images. And this would be then under the online safety bill. However, WhatsApp have turned around and said, no, we're not happy to do this. So I will pass over to Peter to continue with this.
Thank you, Amelia. So this is WhatsApp, the story that keeps on giving. And we've talked about that an awful lot in these discussions. Just one final reminder for those at the back, we shouldn't be using WhatsApp for business-related activities because it is not entirely secure and you can never be entirely sure where its servers are located. So from that perspective, if you are certainly in a highly regulated industry like, for example, law, accounting, medicine, financial services, pharmaceuticals, you should really be not using WhatsApp for sort of internal communication amongst staff and teams or for communicating with any other third party. That said, we're talking here about the fact that it is a platform that is often used to facilitate the sharing of indecent images, child sex abuse images, and indeed increasingly is used as a platform to facilitate crime, to facilitate abuse in many different forms, and in the past has always also been linked to the facilitation of terrorist offences. That is why the government is very keen to be able to have some form of control and regulation enshrined in its online safety bill, which has been consulted on, of which final proposals have been laid before Parliament. And the Culture Secretary, Nadine Dorries, is keen to ram through the UK Parliament. However, this has all been delayed due to the fact that currently the UK has a caretaker government until a new Prime Minister is selected and appointed by the Queen in September. Now, the point here is that it therefore looks like this bill will become law, particularly as the candidate Liz Truss, who currently is the bookies' favourite to win the vote amongst members of the Conservative Party. She has the support of Nadine Dorries, who has endorsed her, and it is probably quite likely, I would have thought, that Nadine Dorries would say, I'll endorse you, provided I get to keep my existing job, because I'd like to nationalise privatise Channel 4, and I'd like to make sure this bill becomes law, the online safety bill. So it's been delayed until the autumn, but it's more than likely now going to lead to a conflict, because WhatsApp is saying we cannot reduce our security levels, i.e. the encryption that they have, whereby each user's device is encrypted, as is the server where the WhatsApp communication is stored. So they're saying, look, we will keep that secure. We are not going to use AI or other systems to be able to monitor the communications that are on there. We don't engage in the monitoring of those communications. That would compromise the perceived security of the platform. So in other words, they're saying we will not comply with the measures the British government is asking for. What that then leads to could be, who knows, enforcement action, fines, the UK government saying we don't want this platform to operate in the UK. Who knows? That could be a problem in that many organisations rely on WhatsApp for communications, rely on it for deliveries to customers, rely on it for a large number of purposes, and therefore switching it off would have an inevitable impact on the British economy, not to mention be a bit of a message that Britain is perhaps not the home for innovation and technology that it has portrayed itself as in the past. So very significant implications here, with the boss of WhatsApp saying, look, we simply aren't going to back down on this, and the government more than likely in the autumn saying, well, we're going ahead with this. So increasingly it looks like this isn't going to be sort of settled and measures agreed behind closed doors. Instead, we've got WhatsApp sort of putting up its shield and sword and saying, well, we're going to have a fight on this, and the government saying, yes, we are going to have a fight on it. So who knows where that one will resolve itself, but it could get very, very messy before it gets to anything like any form of resolution between the parties.
No doubt, certainly this is something we will be discussing again. And like you've already said, WhatsApp comes up regularly on this podcast, so we'll see what gift they give us for next week. Moving on to our next story. So this is looking at a cyber attack. So cyber hackers have targeted a housing association service in central and southwest England. So this is in Bromford, and so Bromford has around 40,000 homes in the region, but its chief information officer has said there is no evidence that the hackers have actually been successful in gaining any personal data here. However, I think most importantly is the fact that this story has been circulated and they are coming clean and saying, look, we have actually been hacked. And that's an important point that I'm sure Peter will unpack for us.
Indeed. So the point here is that it looks like the system has been compromised. They've shut this housing association has shut down its systems as a precaution. Bear in mind that a housing association has a huge amount of personal data. So we're talking about the provision of services to about 90,000 people. So that will be details about their homes, details about rent, about payments, about tenants, about families, about occupancy dates, dates related to when they may have occupied, dates when they may have moved out, new tenants moved in. Huge amounts of personal data, not to mention references perhaps to payments, people's bank accounts, sort codes, contact information, email addresses, home addresses, phone numbers. We're talking about a lot of personal data. That's before you then think they probably have to confirm who they are. So things like ID might also relate to people's financial status, which is something that as a housing association they might have to means test before being able to provide housing. So lots of personal data, a very rich source of personal information here. So you can see why a hacker would be keen to try and exfiltrate some information out of them if they could. Now they're saying, look, we've told people that there has been a problem and our system was closed down as a precaution, but that they don't think there has been a problem in terms of their data actually having been compromised. But they have taken the precaution of telling all of their data subjects that this incident has happened. And you might ask, well, why do that? Wouldn't it be easier just to stay stum and not say anything to anyone? And this is an example of the increasing, I think, forward-facing view of public relations when it comes to dealing with hackers, data protection breaches, etc. Sometimes it is better to sort of send up the balloon and say, yes, we have been compromised, rather than people hearing about it secondhand, whereby someone might find that their data is available and has been used for a purpose they didn't authorize, or indeed if the hackers end up actually then publishing information somewhere else. That would then show that the system has been compromised and people are finding out from someone else rather than the organization that is indeed the data controller who should have been responsible for safely looking after all of that data in accordance with the UK GDPR and the UK Data Protection Act. So in this instance, it's almost being on the front foot to say, look, we've had a problem. We are holding up our hands, saying we've had a problem. No need to worry, nothing to see here, and we're doing our best to make sure that the data stays safe and we're doing something about it. So increasingly that becomes a better way of handling it rather than trying to keep a lid on it and then finding that news escapes from somewhere else. In particular, I think it can be an issue if, for example, that news escapes due to a poor quality of service being delivered or people complaining and then finding out that, oh, it turns out that your data may have been compromised. That is what led to such and such a function not being carried out, which is the reason why then whatever service wasn't carried out, or you were affected in some way due to our error. Much better to be on the front foot and open and honest rather than the truth being dragged out of you with a pair of pliers later on. So that's an example of this, and actually an example of sort of trying to put a positive spin on it. And in this way, it's then sort of something that's a sort of in a small piece of news rather than a big piece of national news when, you know, a cover-up that is worse than the crime that might come out. Because if it then comes out that, well, they didn't tell their users and they didn't tell the data subjects, that's more of a story than, oh, they were hacked and they're now trying to do something about it.
Thanks, Peter. And that very nicely leads us on to our next story. And so this is looking at the law firm Ince Group, which collapsed to the lowest ever level yesterday after it said 8.6 million fundraise was needed to ward off financial problems. And this is as a result of a cyber attack that they suffered in March, which is estimated to have cost around 5 million. And so here we're really looking at the effects that a cyber attack may have on a business. And I will pass over to Peter to really understand why and where this 5 million has come from.
Thanks, Amelia. Yeah, there's a long list of things that can end up being the consequences of a cyber attack. So anything from money's actually being intercepted, exfiltrated by a hacker. So then, for example, being able to get command and control of an account system, to be able to facilitate payments or being able to intercept payments is a frequent outcome of a system, of an organization being hacked. But there are other ways that losses can be incurred. So, for example, it could be in a form of compensation paid to affected data subjects. It could be through any breaches that then flow that mean other parties whose data you may have been processing and storing, they may have to then have compensation paid out for the terms of the service level agreement, for example. There can then be other penalties. There can be losses from, for example, colleagues, staff, directors leaving and taking business with them can lead to a financial hit. And then, of course, you can actually get investigated and fined by the Information Commissioner's Office. A loss in terms of market value is something that's less common when it comes certainly to law firms, because while law firms can have non-lawyer ownership under the terms of the Legal Services Act and alternative business structures, it's still quite rare for that to have been utilised, certainly in the UK, though albeit it is becoming more common year on year. But in this instance, this is saying that the value of Ince & Co shares has been affected and they've had to go and raise a significant amount of money. So more funding from their bank, also more money through a new share placement. Because in this instance they had a problem with internal systems being compromised, even though they have made the point that, look, we don't think that client data was affected in this. So it's more a matter of processes, time recording, invoices being compromised. So that's leading to a net loss there, of course, if your financial records are not available. So I think there's some key lessons here. One is that they're saying this is a 5 million loss so far. And in that, they'll have had to report this to the Information Commissioner, they'll have had to report this to the Solicitor's Regulatory Authority. The outcome of their investigation could lead to fines, and therefore that 5 million does not include a regulatory fine. But it could do further down the line. The ICO may fine them, the SRA may fine them. The other thing they say is that recovery from these disruptions was, and we quote, longer and slower than anticipated, and the disruption to the group's normal way of working has had a negative impact on both people and systems. So this is running home the point that firms need to have good disaster management and disaster recovery plans in place. So you need to have clear business continuity to hopefully allow for the resilience of systems like this, and also for fallback and backups, so that this does not take a long, slow disruption over a long period of time before the business returns to business as usual. So you need to have clear business continuity. You need to be able to then have an incident response plan and indeed a disaster recovery plan where appropriate, in order to ensure that you are minimizing your risk and damage from the recovery from an incident like this. And only through doing that can you then hopefully minimize the subsequent losses. In this instance, they're saying the impact has been 5 million, and that's been submitted in a initial insurance claim. So there could be further insurance claims that will follow. What do big insurance claims lead to? Higher premiums. And we know that professional indemnity insurance premiums for firms can be very sizable as it is, and they're looking at significant increases in costs due to the cost of living and inflation issues that are certainly affecting the UK this year. You'd be expecting your premium this year to go up anyway, probably between 5 and 10%. More than likely, that premium will now be significantly larger due to having to make a claim of nearly 5 million potentially on their indemnity insurance policy. Though it does make it clear, it doesn't say that this is a PII claim. This could be a claim on a cyber liability policy. But as always, you need to check a cyber liability policy to make sure it covers you for these sorts of losses. Surprise, surprise, an awful lot of policies will try and exclude coverage for certain types of losses. So hence, it is always worth checking that the level of coverage is provided, and also don't assume that, for example, all of the losses that you have put together into a global figure like that. Do not assume that the policy will cover them all. And furthermore, it's saying this is an initial claim, so therefore further claims could follow for the issues related to, for example, regulatory fines and enforcement, or indeed the fact that they may end up facing a class action from affected data subjects. You could get each individual data subject potentially claiming a few £1,000 in compensation, depending on the number of affected data subjects. That could be a potentially large cohort as well. So that 5 million is probably the very tip of the iceberg, and it looks like they're already struggling for funding, and they may have to make further calls for find new sources of money to keep their head above water before this incident has totally run its course.
Thanks, Peter. And that funnels us in nicely to another hack that happened, and this is the Derby legal firm Nelson's. And Nelson's recently experienced a cyber attack, and this actually kind of doesn't fit with what you've just explained, in the sense that they did not decide to inform any of their clients for 6 weeks. And there's actually a quote here that came from one of the affected clients. He remained anonymous, however, this is what he said. "It's not good. It was out there 6 weeks previously before they notified me. That's strange. From my point of view, I'd have preferred to have known straight away so that I could have acted." I mean, I think that sums it up nicely, and that's from the mouth of the client. So I will pass over to Peter to kind of talk about this further.
That's a really good point, Amelia, with this one. That sometimes, particularly where there are affected data subjects, you would need to demonstrate to the Regulated Information Commissioner's Office that you are supporting the affected data subject. That's the sort of thing, for example, that if you are then reporting a data protection breach within 72 hours of the date of knowledge, one of the things you should be telling the ICO is, how are we supporting the affected data subject? Now, if you aren't informing the data subject until 6 weeks afterwards, that might suggest that that data subject isn't being very well supported. Now, we don't know if, and it could be that that data had been compromised for 6 weeks, and only then have they found out. So they could have been within that 72-hour window of date of knowledge, and that's when they've then told the client. But if someone has had command and control of their system for that 6 weeks, I'd want to know that as well. So it looks like an approach on this one has been made almost of knowledge is power. It looks like of the affected data, looks like it seems to be a fairly small cohort of clients that have been affected, and then subsequently only telling that limited number of clients who have been affected of the breach. And overall, they're saying it's only less than 2% of clients' data that has been compromised. And then, of course, they'll report in external experts to try and help, and then try and restore their systems and backups, etc. But the point here is that, the IT systems of a highly regulated entity like a law firm contain an awful lot of very sensitive personal data. Some of the most sensitive information you can have are issues that you are taking legal advice on. It could be anything from someone's estate to a property that you're buying, to financial interests, to issues related to childcare, to divorce, to personal injury. Inevitably, the information held on file about a private individual by a law firm will be sensitive. There's no two ways around it. So in this instance, you'd probably want to be telling them the minute that you find out that data has been compromised. So really, I think the lesson to take from this is, as we were saying earlier on, like the housing association was doing, is get on the front foot. If you are compromised, if your systems are compromised, why not tell the clients to make it clear, look, we're telling you now, we're telling you, for example, in this instance, we don't think your data's been affected, but we wanted you to know. Because to put it bluntly, and this is what that client will be thinking, he'll be thinking, great, well, from the point that my data was compromised, that's probably then been hawked out for sale on the dark web. Who knows who's then got it? If I've then received spurious spam and malware and ransomware and attempted communications, attempts to induce fraud, all these sorts of things, if that has happened, I would want to know that I'm at an increased risk of those communications being fraudulent if they are coming through as a result of having been hacked in its way. So in other words, I would want to have been forewarned and forearmed by my law firm that data had been compromised, so that if I then did get an uptick in these sorts of communications, I'd know what they were and be able to do something about it.
Precisely. Thank you, Peter. So going back to looking at cyber scams. So a new cyber criminal trick has been reported in which an attacker sends a simple message such as "Hi Mum" with a reason for using a different phone number, followed by a string of messages explaining a supposedly difficult situation which requires financial assistance. The objective is to trick the victim into sending money to the criminals behind the attack. So this is actually very similar to the "Hi Mum" scam that we covered earlier in the year. And I think for the people in the back that didn't see this, we're essentially talking about the exact same thing again, where people are receiving these messages. I mean, the attackers here are preying on your emotional ties and thinking, crikey, if you heard that your son or your daughter was in trouble, you'd instantly jump to try and help them. And this attacker is literally just trying to bet on the fact that you would be willing to send money. So I'll pass over to Peter to continue with this.
Exactly. Thank you, Amelia. I mean, this is indeed playing on the idea that you would want to help a loved one in need. It's actually a variation on a scam that's been going around for quite a few years now, where sometimes the scam goes out saying, "Hello, I'm so and so. I my friend or family member. I am stuck in Spain. Someone has nicked my wallet and phone. That's why I'm using a different number to get in touch. Please, can you send me some money so that I can sort myself out?" Now that one's been around for a long time, and in this instance, it's one that's getting in touch saying, "Hi Mum," or whoever it may be. But the point is that this is a very common scam, and again, it's the sort of thing that you need to look out for. But for example, just going back to our previous story and the firm Nelson, this is the sort of thing that client would want to know, so that if he thinks, "Oh, my data has been compromised," and then later that day you get a "Hi Mum" text or something along those lines, as if to say, "Oh, there's a friend or family member who needs some money urgently," you'd have even more reason than usual to think, "Oh, this doesn't look genuine at all," and that's really the point. As always, it's a matter of almost training yourself to sort of spot these sorts of things. We've got to the point now that I'm very, very reticent about replying to messages that I'm not replying to messages I'm not expecting, and certainly I ignore any requests for money. To the point that I've actually ended up having to query before now emails from my own accountant saying this doesn't look genuine, and they say, "No, actually they are genuine, and yes, we do need payments of X, Y, Z, or confirming that I do need to click on a link to access a secure document." So you almost to get to that sort of trust no one, trust nothing, and query everything state of mind. I think there's a lot to be said for that when so many scams of this type are out there.
I think that's certainly something to mention as well, Peter, because I believe we only had a conversation this week in relation to an inquiry that came in, and as a team we all sort of looked at it and queried as to whether it was in fact a legitimate business inquiry or whether it was some form of scam. And it is just getting into that mindset of, does the email address that this has come from look slightly strange? Does it include a lot of numbers? And kind of looking at, does this kind of fit with what this email is saying? And I think that's probably one of the key things when you're looking at certainly email scams is, where has this come from? Have they included some form of email address, and does it fit with the context?
Exactly.
So moving on to a slightly different story now. So last Thursday, Judge Sarah Monroe QC made English legal history when she passed a life sentence on Ben Oliver, a very dangerous man, for the lawful killing of his 74-year-old grandfather. However, the key thing here is the fact it was broadcast to the nation on every news bulletin, where she explained the difficulty of balancing factors in sentencing a case of this gravity, complexity, and sensitivity. And so this is really interesting in the sense that this was actually broadcast. And if you were following the Johnny Depp case, where the entire case itself was broadcast, this is very different in the UK, where typically any sort of news coverage, even pictures, are kind of drawn. So this is a very different take as to what typically happens in the English legal system. So I'll pass over to Peter to talk about this in more detail.
Thanks, Amelia. This is a fascinating story because indeed we rarely, if ever, allowed cameras into courtrooms. So to have a sentencing like this on network TV is a big, brave step by the judiciary. But I think it is an overdue step, and I hope it is the first of many instances where different aspects of courtroom procedure, in particular in relation to criminal law, do end up being broadcast on TV. The point being that faith and understanding of the system by the general public is very, very low. You only have to read the book by the secret barrister that sort of chronicles some of the instances of public misunderstanding as to the criminal justice procedure to realise that actually having things like this, a sentencing televised, where the judge explains this is the reason why this individual is getting this sentence, and even sometimes actually explaining what that sentence is so that it cannot be misunderstood or be reported in a way that is in any way ambiguous, has to be a good thing. It's got to the point that over the years you get tabloid newspapers who misrepresent and misreport the workings of the justice system, which lead to criticism of judges, criticisms of their decisions, and criticisms of the system as a whole, which people simply do not understand. And indeed, no one's really got an experience of it unless you've been through it yourself. I've been through it as a criminal solicitor many, many years ago. And it was a real eye-opener to spend the best part of 2 years looking at how the criminal justice system works. Other than that, your only experience of it is going to be if you're on the other end of the criminal justice system, which is none too pleasant. But the number of times I found myself advising clients saying it's not like in American TV dramas, I'm afraid. This is how the system will actually work, and this is what we can or can't do. Was always a real uphill struggle, and that was the best part of 20 years ago, and it's probably got a darn sight more difficult since then. Now, the point here is that, I think we could end up seeing more sentencing like this. Whether we get whole trials televised, certainly in the Crown Court, I think is unlikely, because certainly I don't think you could televise witnesses giving evidence, because of the possibilities of intimidation and threats that could follow for those witnesses who might be discouraged from giving evidence in future. I think it is possible you could get, say, the opening statements by prosecution and defence could be televised, because that actually will, I think, be helpful for people to understand what evidence is actually being offered by the state and what evidence is being offered by defendants, as well as actually then seeing other aspects of procedure as well, and things like the sentencing absolutely would. I hope that we see more of that, particularly as the sentencing follows the verdict. So by this point, we know that an individual has been found guilty, and we know the nature of the conviction, and it's then just a matter of seeing the sentencing and seeing why a certain sentence is deemed as being suitable by the court. So hopefully we'll see more sentencing like this. Will we see more aspects of court procedure televised? Perhaps. I think it will be a good thing if we did, but I don't think we'll see the entirety of court procedure televised. I think things like having, summing up certain things, I don't think will be helpful. And I think as well, it could be that certainly I don't think you'd televise it live as has happened in the States. Simply because I think it might be, for example, useful to see, say, what a prosecution case is after the individual has been convicted. So you could then see that. In that, sometimes it takes a few hours as well for a prosecutor to open a case and run through all of the evidence and explain what the court's going to see. I think seeing that after then a verdict has been given would allow the public to see, oh, wow, this is the nuts and bolts of actually what happened here and what's taken place. And this was the evidence that they had. I think would be really, again, in the interest of justice. So not necessarily live TV, but certainly having it recorded and available like this post-verdict, I think would certainly be a bonus. But in the interim, I think there'll still be plenty of work out there for the court sketch artists. Just for the avoidance of that, I don't think we're going to be seeing cameras in civil court, so in the High Court or County Court anytime soon. Just because of the sheer range and nature of the different issues, and means that very often it wouldn't be suitable for televising. But for those who have a burning desire to think of what actually was going on in the courtroom when it came to, for example, Colleen Rooney and Rebecca Vardy, I still would have thought that would remain behind closed doors more than likely for the foreseeable future. But who knows? It may be that if televising of verdicts here of sentencing in Crown Court is successful, you may see a similar proposal eventually being rolled out in the civil courts as well. But I would have thought it would be unlikely for the time being.
Thanks, Peter. So moving on to our next story. So this is looking at the Solicitor Regulating Authority. So this is actually a news story that they had put on their website. And this is in relation to emails that have been sent misusing the name of Mercer's law firm regarding a supposedly unclaimed inheritance. And so I'll hand over to Peter to talk about why this story is important, sort of aside from the context here.
Yes. So here it's quite interesting with regards to these type of frauds. We've had individual hackers impersonating law firms quite a bit in the past. I think this story highlights, well, what can you do to check if a law firm or a communication is genuine? In this instance, you can check, is Mercer's a law firm? Yes, it is. And the SRA have issued a notice with information on there in terms of exactly what their correct domain is. And then, for example, the fact that in this instance an email was being sent out with a Gmail address would show that therefore this wasn't a genuine communication. There are other giveaways. If you look at the SRA's notice on this, it describes what a scam is and what fraud is. But then it says, the SRA understands a member of the public was initially approached by an individual claiming to be called Sir Lancelot Bridge. I think that's the first clue, because if anyone walks around with that sort of name, wow, is all I could say if they were working in a law firm. Then the fact that those transactions are being taken place with an email address of la.bridge001@gmail.com. So therefore, if someone purports to get in touch with you and say, hello, I'm acting for an estate and I need to give you hundreds of thousands of pounds you're entitled to, would they be doing that using an email at gmail.com? No, is the answer to that question. And that is a further indicator that, look, this is probably going to be a scam, as is the fact that this all adds up to be wrong. But I think the good takeaway here is that you can check this information. So, if you ever receive an email from someone purporting to say that they are a lawyer, you can go and check on the SRA website, and they have a list of all of the solicitors qualified in England and Wales, and you can go through and enter the name and see if it comes up. You can enter the name of a law firm and see if that comes up. You can do the same thing on the Law Society website, lawsociety.org.uk. Just type in "find a solicitor," and you can do the same thing on their registry. And the same goes for any other regulated individual. So if you have someone who purports to get in touch with you who is an accountant or a doctor or another regulated professional individual, check the registration. Are they genuine? Then you could find out, they're, in this instance, does this person work at Mercer's Law, you'd be able to go and find out that no, there isn't someone called Forlonge Forlot Bridge who works at Mercer's Law, and that would be another red flag. So there's ways and means of being able to check registration details to outwit the scammers and the fraudsters. I think this article is an excellent indicator of how to use those sort of basic tools to try and protect yourself from these scams.
Thanks, Peter. I think it's really key, like you say, that the fact that us as legal professionals, there is a way to check when you are kind of being given a piece of information from someone as to whether it's true or false. And when I actually sent this story over to you, I mentioned the fact that we received a letter last year from a individual, and we then actually ended up checking this individual against, I believe it was the SRA register. And in fact, then we did find this specific individual on such register. And it was actually using this tool that proved very useful when we were looking into this specific matter. And I think it's just important that people are aware that these tools do exist and they're free to use. You can literally go on and search someone's name.
Exactly, and in that instance, we found someone who was engaging in certain actions unbecoming of a solicitor, so we were able to report them to the regulator, which was, great for the peace of mind of us and for our client who was being given a hard time. So yes, registers can be double-edged swords in that regard as well.
Thanks, Peter. So moving on to our final story of today. So this is kind of stepping away from the legal side of things and looking at a computer scientist. So a computer scientist who claimed to be an inventor of the digital currency Bitcoin has won a libel case against a blogger who said that he was a fraud. So Craig Wright won the case against Peter McCormack, but was awarded only £1 in damages after a judge said that he gave deliberately false evidence. So I mean, I won't lie, I read the story and then I reread it a few times to double check that there was no sort of M missing off that title of a pound. But in fact, it was just a singular pound that he was awarded. So I will pass over to Peter to look into this further.
Thanks, Amelia. I mean, this is a fascinating one, this, with the idea that the founder of Bitcoin, the notorious Satoshi Nakamoto, could have been hiding there, and it could have been this individual Craig Wright all the time. Now, the weird thing is that Craig Wright has spent an awful lot of time and money saying that he is Satoshi Nakamoto for a number of years. And in this instance, someone called him out on it. Craig Wright then sued the individual who called him out. And unfortunately, Peter McCormack, who said this, had said, look, I'm not going to defend this on the grounds of truth, i.e., he is or he isn't, thinking it wasn't really possible to establish it. It's more than this whole libel action has been based on, well, did the actions of McCormack lead to a consequential loss and damage to reputation for Craig Wright? And the court has basically said, yeah, you may have had damage caused, but because your evidence on the extent and scope of that damage was so unreliable, we're only going to give you a nominal pound. Not much at all. I can imagine that Mr. Wright would have expected he was going to get significantly more than a pound out of this case. Furthermore, it would be interesting to know what happened with regards to costs in this matter. Has the court turned around and said you'll have to rely on bear your own costs each, which, if it's gone to the High Court, would be in the regions of tens of thousands of pounds by this point, or has, for example, has this court decided to give Mr. Craig Wright can he recover his costs from McCormack? Given how scathing the judge is about Craig Wright, I suspect that he hasn't given him costs either. So they probably had to bear their own costs each for having got this far. But I may just look up the actual decision on this just to see what's done, because I find that the more interesting outcome in terms of what's happened to the costs than the actual nominal pound that's been awarded, funnily enough.
Thanks, Peter. So that was our last story of today. A big thank you to Anson Evaluate for helping to produce this webinar, and we will be back next week. Just a reminder that these episodes are available on our website, our YouTube channel, and podcast channels as well, such as Spotify and both Amazon and Apple Music. Thank you for listening, and we hope to see you again next week.